everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are.
Welcome to another edition of The Community and the Law. I'm very super excited to have this program hosted today. I'm just standing in the gaps of my brother, Owusu Frimpong. This is The Community and the Law, and education that will bring the law into the community, or the community into the law. It's one of our days that we are going to talk about legal matters concerning family law, immigration litigations or dispute resolution, and even our Ghanaian law. I'm super excited. You stick and stay with us as we digest into so many things concerning us regarding the law. And I believe at the end of the day, you definitely get your answer that you are looking for. Just stick and stay. I'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back. That's another edition of the Community and the Law. My name is Manya Nate. I believe you are going to be with us till we finish this program. I'm going to introduce our resource person for this program this afternoon. One of our lawyers. He's been with us for quite some time. Yesterday, I believe those of us who watch us, he was with me, and today too with him. So I'll straightforward go on and introduce lawyer Charles Asma as few things that we are going to talk about today concerning the topic itself. Before I bring the topic, I will allow him to give you a special greetings, and after that, I'll introduce the topic, and then we can just continue our conversation. Welcome, Lawyer Asma.
Thank you, Na. How are you?
I'm very well, thank you. And how are you?
We are blessed to enjoy this wonderful Saturday afternoon. The weather is good, and I suppose viewers and listeners are enjoying the goodness of nature and God.
Of course.
So, this afternoon, greetings to everybody, our viewers, our listeners,
Mm,
the management and team behind this wonderful project, BWF Solicitors, and the
mhm.
production crew. We say, are equal to all of you? And that's we're going to learn and learn well. Right. Thank you.
Thank you, Lawyer Asma. It's been a while. We've not met this afternoons like this before. I mean, started when we started community and the like, I think one or two occasions I've had opportunity to come on with you on Saturday, but today here we are repeating history, and I believe it's going to be very exciting. Looking at the topic that we've brought today, we know we are entering into technology world, and everything is becoming cards, not books, and everywhere you go, even if you have passport, they still require you have a simple card that you travel or even buy things with. And because of that, there are times we have most of our indefinite or stay or status in our passport. But here is the case: there are a number of times that the Home Office is requiring us to put these status into a card. So today, I'm very excited. We are going to look at how we can transfer our indefinite leave to remain in our passport into a card. So that means when we're talking of card, either we are talking about the BRP cards or biometric cards or any other cards, as we know, where we have our details or our status that shows where we are or what we are in this country. So before we do that, I'm going to introduce you to the nuggets that we have today, and we all know after the program or just before the end of the program, we'll have a special quiz where we pose some questions based on the nuggets that we introduce to you. And after that, we look at our knowledge, we test our knowledge, and then we know whether we are doing well or we are really following the program. So one of the nuggets for today is, if I may read it, producer, yes. Okay, it says, while it is, of course, always necessary for the judge to retain control of proceedings so as to ensure that they remain focused, effective, and efficient. It is also a key part of the judge's role to conduct the hearing to ensure that they get the best out of all the participants appearing before them. All these that I'm reading, actually, they are all legal terms, and I like the way it's trying to bring our mind to these words like focus, remain focused, effective, and efficient. So as I continue, I'm going to invite Lawyer Asma at least to digest this bit of nugget for us before we commence our main topic for today. So to continue, the next paragraph, regardless of the appropriateness of judicial intervention, overbearing and intimidatory conduct directed as a representative could result in an unfair hearing as well as give the impression of bias to a fair-minded and informed observer applying Porter V. Porter V. I believe, or Porter 5. I believe our lawyer really know what this is. These are legal terms, and I believe I'm not a lawyer, you are not a lawyer, but our lawyer here is going to digest. So, Lawyer Smart, and looking at this digest nugget, sorry, I will read it again for the viewers to probably get the gist of it properly. So, if I should start reading again, say, whilst it is, of course, always necessary for the judge to remain control of proceedings so as to ensure that they remain focused, effective, and efficient. It is also a key part of the judge's role to conduct the hearing to ensure that they get the best out of all participants appearing before them. Hmm. These legal terms, Lawyer Asma, can you just break it down for us, or for our mere, someone will say, down to our level, please, if it's possible?
Sure, very possible. Thank you very much, Now, so, viewers and listeners, the reference point or the application of the law, we are looking at the case of Porter versus McGill. Porter versus McGill, 2001, and it's UK case, and we call it judicial intervention. Again, we are looking at a case of Bangladesh, and it's a fresh case reported 2023 and UK Upper Tribunal. So we are looking at judicial intervention. When we say judicial intervention, what it simply means is that the judge, who is the referee within the court or at the courtroom, can intervene when necessary with the best of intention to ensure that he or she conducts the affairs of the proceedings in a way that is cordial and smooth. So the key point is judicial intervention. The judge stepping in to control affairs so that the two barristers or the two lawyers or the two parties do not fight unnecessarily among themselves and create chaos in court. So that is first point. The second point is, what is the level of intervention that the judge must have in the courtroom? And that's very crucial. So it says that regardless of the appropriateness of the judge's intervention or the judicial intervention, if that intervention is overbearing, if it's too much and intimidatory, then that if that intimidatory conduct is directed at a barrister or one of the lawyers, a representative, that could result in an unfair hearing as well as give an innocent bystander or somebody who is in the courtroom and watching on impression that the judge is being biased. And this person, it has fair mind and been has it has information about what is happening. So that is the point we are making. That what we are simply saying is that if the judge does that,
Mhm.
then that can trigger bias. And one of the parties can say that the findings or the decision of the court is not fair in that regard, and therefore there has not been fairness and justice in the affairs of the proceedings, because the judge has to be um, fair to everybody. The judge has to be independent, and the judge has to make sure that everybody has fair hearing and everybody is treated equally and fairly in the courtroom. So, if, for example, a judge becomes a cross examiner, asking a lot of questions that the other party should be asking the, one of the parties, then the judge is taking over the job of a representative, and that is not fair. Then we can assume that the judge has already made up his mind or her mind, and with a view to asking those questions, the findings will be that this is the case, and we can conclude that, well, you've already made up your mind. That's why you are asking a lot of questions that you should not be asking. So we are saying that the judge can intervene, but the intervention should be fair and should be appropriate. And therefore, if it is too much and it is intermediary, then it can be concluded that the judge is being biased. And if the judge is biased, then the person who is ruled against can appeal against the decision of the judge on the basis of bias, unfairness, and unjust finding.
Wow. So, with the explanation, does that mean, suppose the outcome of the proceedings, maybe the case between the state or the home office and an individual, and the judge looking at the proceedings, we could realize that biasness in this case, but then the outcome really came out in favor of the individual. Can the home office also goes on to go against this, and then maybe appeal or something like that, because the judge being biased against them? Can that be?
Yes, it's either party. If either party feels that the judge applied overbearing and intimidatory conduct with a view to take side and eventually um, ruled in favor of the other party or
Mm-hmm,
found in favor of the other party, then the party that is lost
mm-hmm.
lost in this case can say that the the decision is not safe because the judge was not being fair. So it could be the party, either the home office or the individual. And remember, this is not just about immigration. It's across board. Anything that has to do with a judge making a decision, what we are saying that the judge can intervene to ask questions, to seek clarification, and to be seen to be doing the right thing as long as it's within his or her job. However, the person has to be very careful not to overstep boundaries with a view to concluding that the person has already made up a mind to decide in this way. So there should be no clue at all.
Oh, okay. Well, it sounds a little bit strange in my ear. I mean, looking at some of the court proceedings that I've attended before, you could see that it's the judge actually doesn't say anything until these two lawyers, either against and for both parties, they've actually finished or given out their cases before the judge comes in to, just go on with the outcome of the case. So in this case, how is it possible if the two parties have their representatives and they are representing them with their issues, and then the judge can just overshadow them or just ignore them and then pass on these questions to the individuals or to the participant or the people that are standing in trials, anything? How is it possible? Is it not the representative? They are supposed to, I mean, give out their what's the term? Giving to give out their proceedings to the judge. So how come the judge can just overshadow them and then just start talking, and then we can see that biasness in his proceedings?
Right. So the key word is impression being created by
Oh,
the judge. The judge is the arbiter, and he is the referee or she is the referee,
mm,
and his or her conduct must be seen to be free and fair to both parties. So let me give you a classic example. Um, sort of a scenario where in call room, let's say we are in call room, and there's cross-examination going on. So the other party's representative or lawyer has a chance to cross-examine the other party
Yeah.
about whatever the matter is. Now, the person, the lawyer is cross-examining the other party. Then, for example, the judge intervenes to say, um, Madam Mayeteng, you are asking too many questions. Can you cut your questions down? Then it's okay, my lord or judge, these
Mm.
questions are necessary to be able to determine the facts and to understand the issue.
Okay.
So uh, um, the witness is here, and the witness is the one who has to provide the evidence. So these questions are appropriate. Then the judge, for example, says that yes, they are appropriate, but you're asking too many questions. Don't you have everything already? You should just narrow it down. So every moment the judge cuts in. Yes, maybe the person might be asking questions that are overboard or not necessary. But the approach the judge uses to intervene is very important. But for example, when I said what I said, you were laughing because the impression the judge is creating is that, oh, just cut it down because I know where the conclusion is going to go.
Okay. Okay.
And that is not fair because anybody will say, well, the judge is being biased. Why is he doing the other person's job for them?
Mm.
So it's very important that the judge is very fair. You are going to intervene, just like a parent separating or dealing with the matter of two siblings. If you are the parent, you have to be fair to both siblings. So whatever you say or do will create the impression that you are siding against the other person for the other. And that is what we don't want to happen in court. And therefore, even if the other party loses, the person will say that because of what the judge did, that
Mm.
is why he ruled in this way, because the judge had already made up his or her mind. And
Mm.
therefore, he's not fair or is not being free.
Mm.
So the impression is very important in
Mm.
judicial intervention.
Okay, so this impression must be observed by both parties, isn't it? It's not because obviously when the case is going for you, you wouldn't see that there is a bias against the other person because the case you can see that you are rather winning the case. So it should be observed by both parties before it can be accepted that the judge has been what exercising this pressurizing the other parties or being biased in this case. Can that be?
Yeah, I mean, each party is running their own case or affair in court. And
Mm,
if you think that the judge is being biased or judicial intervention is overbearing and intimidatory,
mhm.
you can make note of that and
Okay.
wait for the decision. Once the decision comes and it is not in your favor,
Yeah.
you look at what has transpired, knowing what has also happened in court, and raise a point that the judge was being biased because of XYZ, and therefore relying on the case or the ruling in the case of Porter versus McGill and also that of Bangladesh 2023, I want to appeal against the decision of the judge, regardless of how good it is, because that is not safe enough
Okay.
because of the bias.
Okay, so when you appeal, in terms of the appeal, when you appeal through the process that you've just said, when you appeal and the outcome becomes the same, will you, I mean, give up and say, well, whatever it is, that this is still the final judgment, or you can still go ahead because the whole court issue is you want it to be in your favor. So here is the case, it didn't go into your favor, and you've appealed based on the intimidatory and the biasness of the judge, and then you've appealed, and then even after the appeal, still the court hearing still went against you. Will you just end over there, or you still continue to um, go on to appeal for the second time?
Right, I mean, you see, the process continues up to Supreme Court.
Okay, then.
Supreme Court becomes the final point.
Yes.
So from the first year tribunal
Mm-hmm.
or the district court up to wherever you want to go, you can reach up to Supreme Court depending on the case.
Okay.
So if your case has merit and you can appeal against a decision. You can continue to appeal to any level you want. The last limit, as I said, is the Supreme Court. After Supreme Court, you just leave it to God.
You leave it to God. You leave it to God. Thank you, Lawyer Asma, for breaking down the nugget for us. The nugget again is on board, and getting to the end of the program, we'll be asking some few quiz. I mean, we'll have a quiz on it, and I believe the answers will be right there. So take note of it. You can read it over again, and then you get your answer right. Very soon, Christmas is coming, and when it's Christmas time, BWF Solicitors, we are noted of giving away nuggets and what? Presents. So one of these days will start soon, very soon. It's almost half of the month, the year already, and we'll be gathering some few things, in preparation to this Christmas bonanzas. Okay, then, and ladies and gentlemen, if you have just now joined us, this is BWF Solicitors, the community and the law, and I'm here with Lawyer Asma. We are trying to break down some few things based on the nugget that we brought, and now another segment that we are going to look at how do I transfer my indefinite leave to remain in my passport to a card. Now, first of all, I'm going to ask this card. We know I saw someone recently with a wallet, and the wallet drops down, the kind of cards I can in fact I remember very well. I could testify that about 50 cards in that small wallet. Wow. So cards, like Asma, how do we do that? How do we transfer something in our passport into a card? What will be the process? Where do we start from? Is it really necessary? Why must I go, or why must I do that? Can you give us that a little bit of breakdown? And then I can be asking the preceding questions whilst we go on.
Thank you very much, Na. So, viewers and listeners, today we are looking at people who have visas in their passport, and those vignettes are stamped or fixed in the passport, but that is indefinite leave to remain. So, in the past, that is what you get. It's a stamp in your passport or a vignette placed in your passport, and once it's permanent status, that's all you use. And people still think that because it's in my passport and I keep transferring it into my passport, even if there's card, I don't really need it. Now, we also know that most employers or people that require your right to work or your leave to remain in the UK, your state or your immigration status, are looking for a copy of your card instead of a copy of your visa in the passport. So everything is now transferred onto a card. We have two sets of cards. We have the BRC, biometric residence card, and BRP, biometric residence permit. These are important terms because they are underpinned in particular provisions of the immigration rules. If it is a card, BRC, that is for EU. So the EU members or nationals, when they come to the UK, they are supposed to be given a card to show their residence. Anybody whose status is derived under the immigration rules, i.e., 2.5 or whatever it is, under the immigration rules, Appendix FM, what have you, skilled worker status or whatever it is, you get BRP, biometric residence permit. So that's the difference. BRC, BRP. BRC for EU family members and EU nationals living in the UK. BRP for any other living in the UK that requires a visa. Now, this is what is happening now. So most employers, banks, landlords would want to see the card. So we are gradually forgetting about the visas placed in the passport. So a lot of people will come to us or will say that my employer has asked for the card. But what card is the employer talking about? I have my indefinite leave to remain in my passport. And the employer says it is not. What it means is that because the card is latest and these are the modern trends with the processing and storage of our information, our immigration status information, employers are able to get your status online based on the card information. So if yours is still in your passport, the employer is not able to, for example, generate a share code if they want to have a share code, or it's not able to track it online. And they feel that if it's still correct, you should have been given a card. And to make it easy for them, your job is to transfer. When you are going to transfer, you do, because it's an indefinite leave to remain application, you do not have any limit or restriction on your permit. So you do an application called no time limit. And that no time limit application is to tell the government or the home office that my visa, which is in my passport, is indefinite. Transfer it to a card for me so that I don't have to carry my passport and my visa around. I can just carry my card, which has my status.
Oh, okay. So you have to do the application yourself. You because when you did your application initially and you got your status in your passport, normally when you do the application, I know either by a lawyer or through online your own individual application, you are supposed to send your passport to the home office, and then the home office intend to put your status in or the vignette into your passport. So after you've receive your passport and maybe few days or few weeks collapse, and you want to apply this status onto a card, that is where you began by what the application and the title. You just mentioned something like what no time limit. Is that what you said? No time limit
Yes,
application.
yes, no time limit.
So when you go to the online forms, would that particular title comes up like that, or you know sometimes they I mean people just ask which one and which application form, that kind of thing. So it will come no time limit, and then you fill the form, and then you send your passport with this form to the home office, or you just have to put in your details on the form and then send it to the home office before they will bring you that car. Is that how the process is looks like?
Right. We have to set the context.
Okay.
The context is that anybody who is listening to us
Mm-hmm.
or watching us
Mm.
and not sure whether this applies to you or not, or applies to your friend or family member or anybody you know, all you want to do to start with is pick your passport.
Yeah.
As first, ask yourself, do I have indefinite leave to remain?
Mm-hmm.
But this is for those who have indefinite leave to remain.
Live
Do
to
I
remain.
have indefinite leave to remain? And number two, is it a visa in my passport or a card that I have?
Okay.
So if it's a visa in your passport, then you can see that you had it long ago.
Okay.
Because if it is recent, you would definitely be given a card because you would have done your biometric.
Mm.
But in those days, there was nothing like biometric.
Mm.
So you go, you make the necessary application, go through the process, and they affix it in your passport.
Yeah.
So now everything is going biometric, everything is going online. And therefore, once you check and it is Virginia in your passport, you know that this applies to you or applies to your family member or the friend. Then the next stage is, how do I proceed? You
Okay.
can do it yourself or you can seek the support of a lawyer. The lawyer knows the right form, the lawyer knows the right procedure, and the lawyer knows the right processes. So the lawyer can follow and assist you. However, this conversation is also to offer you knowledge and understanding so that you have the um, general view of how this works. So you check for the form, no time limit application. You have to make sure that you get the right form. You make the application, and this application is free. There's no home office visa fee because you have indefinite leave to remain, and all that you are asking for them to do is to transfer it. It's not that your card is lost and you are applying for a card to be replaced where you pay the fee. This is where you have your visa in your passport, indefinite leave to remain, and you want them to issue a card for that. So
Mm.
it's free. It's free. Application is fee is
Oh,
free. Application fee is free for the home office, not for the lawyer. Let's get it right.
yes, Layasma. The application fee is free for the home office and not for the lawyer. Of course, when you involve a lawyer services, or if you take services from the lawyer, of course you have to make some payment. But if the way you've explained it is just straightforward application, and you need to go online and then download forms and apply and then do it yourself. Yes, I know some people are able to do it. Of course, some are also not really able to do that. So they will definitely resort to the lawyer's services to do that for them. And it's payable, of course. Thank you very much, Loyasma. So that brings me to my next question. Now that you've explained the two cards, the one BRC for the EU residents, and then the BRPs for the UK or immigration. I mean those here, not and people obtaining the indefinite leave to remain. Okay, so now I've made the application. I have my card. And when you do the application, how long does it take before you get the card? Because suppose I'm sending it to my workplace and they've requested for it, and I've told them I've done the application and that I'm waiting for the card to come. How what When we look at the period within, how long does it supposed to take? Because I've come across people that they did apply the card, and over 6 months they've not received the card, and they've not even make any effort to either chase it up, whether it's been stolen or been lost in the system, postage or something like that. So how long are we looking at here, so that in case something of that sort, then we know my time of expectation has elapsed and I need to chase it up.
We know that there is a service standard of usually 6 months for general applications across board. However, it's a case by case point. And what it is that people can receive decisions within weeks, and
Okay.
others can receive decisions within months.
Hmm.
There's no hard and fast rule. There was one time um, a, a call came through from the Home Office and they wanted information about a particular application. And I was asking them, will you be the same person to receive the information once I provide? The person said no. And I said, what do you mean? The person said that they actually have a button they press. So once you press a button, the form drops and you deal with it, just like lottery. So you don't know whose form you are going to work on it. And
Mm,
therefore, whoever is going to work on your application is whoever picks your application. And if the person finishes dealing with it, decision will be made. If the person doesn't finish and stops, and another person picks it, it might be that it will take longer for another person to pick. So it's a matter of waiting for one. But the most recent one I have done, it took about 5 weeks for the decision to come and the card to follow. So I'm not saying that it takes 6 weeks all the time. I'm
mm,
saying that it depends on when the application is submitted and when someone works on it and decision is sent back to us. But generally, 6 month standard.
mm. So does that mean if I've done this application and up to 6 months, there is no result, what must I do? Must I phone the home office, write emails to them, or send them a new application? What will be the right thing for me to do after 6 months, looking at their standard application time period?
Thank you very much. Now, I think our viewers and listeners are very much confident in what to do next if it's not coming. Yes, they know very, very well, but we are just going to revise that.
Mhm.
So, the revision point is that if after 6 months you haven't received it, the usual action is to follow up by way of writing a letter that it hasn't come. That's the complaint. Or you do a pre-action protocol. But you see, we always say we do the pre-action protocol. But pre-action protocol, you are telling them that if they don't do what they have to do, you take them to court. And sometimes you do two, three, four, five, six pre-action protocols, and decision is not come because they say that there is severe delay, there is this, there is that. So if you want to take them to court, are you actually going to take them to court? So we don't want to use the PAP as a threat and to lose its value. So all I'm trying to say is that you just weigh the situation. If it's actually delayed unduly, then you do the PAP. If it's not come for some time, you complain. Then so all we are saying is send a letter, send them an email saying that or reminding them and pushing a little by way of PAP. And they will tell you that they will finish by this time, or they will tell you that it's going to take longer and therefore please wait.
Okay, thank you, Lawyer Asma. Viewers, if you've just joined us, we are Community and the Law, where we bring the law into the doorsteps in the community. My name is Manyati. I'm here with Lawyer Asma from BWF Solicitors, and we are still here. My next question: if you come in just now, please do us a favor by sharing and liking our page in the WhatsApp, in the YouTube page, and then you subscribe to our channel as well. We are streaming live in BW Radio, BW TV, and I believe some of the radio stations also have picked it up whilst we are having this discussion. And very soon, I'll open the telephone lines in case you have questions that you want to ask, maybe concerning what we are discussing today, or maybe another thing. You are still free to do so by the numbers that we have scrolling down the screen. Yes, Liasman, now that we have our BRP or BRCs, and when you were explaining few things to us, you made mention of some companies are refusing to accept passport, even if you send your passport with your vignette in it that you have indefinite leave to remain, and you are entitled to work, you have permit to work, and they still insist that we want to see your BRPs. So if you don't have your BRPs at that particular moment, even though we are talking about how to transfer these visa from your passport into a card, suppose the companies are requesting and you haven't made that application, and they are threatening you that if you don't bring it probably in a certain time, they might either terminate or your contract or stay at home until you get it. What must one do in case you happen to fall into such a victim?
Thank you very much. No employer can tell you that because your indefinite leave to remain is
Mm,
in your passport and that
mm,
is not your fault. Of course, it's not
mm,
your fault. They
mm.
can't say that they will terminate you or
Okay.
they will terminate the employment. They
Mm-hmm.
can only be fair and tell you that we want the card because that is the trend now. So go and get the card. They will give you time to go and get a card. So no employer, and please, nobody should think that any employer will say you don't have a card,
Yeah.
and so they are going to terminate. The
Mm,
most important thing is you have your visa in your passport, and that
yeah.
is indefinite leave to remain, which is unrestricted leave to remain in the UK. So you can work, you can rent accommodation, you can open a bank account, you can live your life legally in the UK. However, the employer wants to be able to check to see if your status is actually online. Because we know that from 2024,
Mm.
actually from 1st of January 2025, there will be no cards. No card at all.
Oh.
No
Mm.
card from 1st of January 2025. And that's why all the cards that are being issued now, the
Mm.
deadline
It's
is
okay.
31st of December 2024. So
Mhm.
the plan of the government or the policy direction is that by 1st of January, or let's say by 31st of December 2024, every visa application will go through the biometric processing, and therefore everything will be available online. So
Okay.
you don't need to have a card. One, it saves cost or
Mm.
money. Two, it avoid the inconvenience of losing your card and having to reapply for replacement. And
Yes.
three, it avoids the temptation of people doing their own cards by way of surviving.
Yes.
And so that is the plan now. So let's remember that The card journey is gradually ending. We
It,
have about 1.5 years for the card journey to end.
mhm,
Now, what we are saying is that the employer cannot say that because you don't have a card and you have indefinite leave to remain in your passport, they are going to terminate you. They will give you time to go and get it. So once they tell you that, you make application and you give them application reference number.
mm,
If they want to know that you've done it, they will call the home office to check.
mhm. Okay.
The reason is that the visa may not have a
Mhm,
um, um, checking parameters in terms of if they use a particular number on it to check, the home office may not be able to confirm is genuine or not. But if it's a card, they can confirm. That's
mm,
why the employer prefer you provide a card instead of a visa. But if I have a visa and I was given by the authorities themselves, they cannot say because I have a visa, you are going to punish me.
mm.
No, no.
Okay.
If they do that, quickly go for, raise their concern and they still say no and they dismiss you, that would be unfair dismissal. So that one, no. We want to assure viewers and listeners that no employer can terminate because your card is not ready or because you don't have a card and you have your visa in the passport and it's indefinite.
Right. Thank you, Lawyer Asma. You see, you said the most of the cards, which of course I'll even say all of the cards have this expiring date on the next year 2024. So after that fading out date, that means nobody is going to use the BRP or the BRC card anymore. All you need to do is probably give your details online, and then your profile will just come out. You generate it with the share code and whatever, and then you send it to the employers. So, looking at the gap that we have now, from now till December 2023, and looking at most of the cards being getting expired within this given date. If I don't have the card now, like today we are telling people to how they can transfer it or how they can do the application. If I don't have that card now, um what will be my consequences? I mean, will it affect my status if it's not about a company requesting for it and I'm still okay with my passport till the expiring date? Would that have an impact on my visa in my passport?
No,
Mm,
because you already have unlimited leave to remain status or indefinite leave to remain in the UK. So it doesn't affect your status. But when everybody is moving, you move along positively. So, and
okay.
that is why once the trend is changed, the employers are flowing in that direction. So they will remind you or ask you to do it. But if you also know that everybody has a card and you think you need a card, you can apply for that. So that at least you don't have to have both have your passport all the time with you if you are not traveling. You can
Mm,
just have your card in your wallet and
mm,
use it wherever you go as even proof of ID
mm,
as well. So those are the things we are talking about. But the point is this: that it's not, even though it's not compulsory, it is advisory that you do it for the reasons we have given. The question is, how do we do it? And that is the purpose for today's conversation.
mm,
So you go online and look for the right form, no time limit application. It comes up and you complete. You have to show when you had the indefinite leave to remain. So you pick your passport and check when the stamp was placed in there or the sticker was placed in there. So you give the date it was issued, when you entered the UK. Just go through the form and complete the form as required. When you finish, you have to provide evidence that you have been living in the UK since you acquired that indefinite leave to remain. And that
mm,
is crucial. So, if I've been living in the UK, if my indefinite leave to remain in the passport was issued 5 years ago, now I will need evidence from that 5 years. If it was issued from 2000 and let's say 10, then I would need more than 5 years. So that is different from naturalization application where you need 5 years evidence. This one, your evidence starts from when it was issued, when your indefinite leave to remain visa was placed in your passport.
Mm.
So some people will say, right, I don't have such evidence, but I've been working. You can get the evidence from um, record, bank record, GP record, or even tax record. You can access your tax record and use it as evidence.
Mm.
And there's one I did. The person had the indefinite leave to remain in 1999. So we get all the evidence. So what we did was to apply online to HMRC. I had the profile of this person, printed everything, all the tax records, evidence of all the P60s, P45s record, and everything was there from 1999. And we used as evidence to show that from the time they acquired their indefinite leave to remain, they've been resident in the UK, and that is the evidence to get it transferred. You process, you send it to you, of course, you book appointment for the biometric, you upload the document, the person goes for the fingerprint, and once the document is there, it's processed, and within a period of weeks or months, a decision is made. As we said, you don't have to pay home office fee because you already have the indefinite leave to remain. It's just a transfer mechanism.
Well, in that case, we are relieved, and we can still move on with our lives. Viewers, welcome back to our program. We'll have just a small commercial break, just about 2 seconds, and when I'm back, we'll continue with our program. If my producer is there, just give us just a short commercial break. I'll be right back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back to the community and the law. Yes, let me just acknowledge some few viewers and listeners on the platform, beginning with Lily saying good afternoon, team. Lily, thank you very much. Good afternoon, everyone. Rebecca Amuakon, thank you very much. And Fida Teza, oh yes, good afternoon. And good afternoon, Fida. Good afternoon, Margaret Edu Mensa. Good afternoon to you all. Margaret says, calling some few names there, Nana Jimai and Co. Good afternoon to you as well, and good afternoon to Sandra Fraser, our Honorable Secretary. Sandra, good afternoon to you as well. Sandra has just put the contact details for BWF Solicitors in case after the program you want to contact them, or even whilst we are on the program you want to contact them for any issue at all, being family law, immigration, litigation, dispute resolutions, and even our Ghanaian law, yes, they are there to support you and take you on with your case. And Sandra, thank you very much. If you're looking for BWF solicitors, the addresses we have, everything there, and the contact number. We have an emergency number, as a matter of fact, in case where you are, the situation is becoming too much to endure. Just call this emergency number, and definitely there will be someone to respond to come into your aid, which is 077 1276 1884. That's the emergency number. Okay, BWF Solicitors is located at Tottenham, Seven Sisters, Tottenham High Road, 214 to 218. Thank you, Sandra. 214 Tottenham High Road. In case you are traveling, we are on the fourth floor on a house, Tottenham, and the postcode for you to travel is N154NP. So that's just a basic information that you need to put on your phone, and you can reach them anytime. Margaret Edu Jemfi, thank you. It's a free legal advice by BWF Solicitors. Margaret Edu Mensa, sorry, and asking everyone to share. Sandra Fraser, thank you so much. Good afternoon, fellow viewers. Thank you for your support. Please share when you join, and which is really true. This is an education that you can't keep it to yourself. You need to share. You need to let somebody also get to know what is happening in the community. We are bringing the law to your doorsteps. Watch us live, BW Radio, BW TV, Facebook, YouTube, and we are there. Tilly Duma, he said, hello, lovely family. Tilly, how are you doing, my dear? Long time. Nana Ajima, free legal education. Nana Ajima, we miss you. Yes, welcome. Says Emmanuel Sechi. It's a good evening now. And lawyer Asma. Good evening, Mr. Sechi. I think after the program, I need to call you somewhere. And Emmanuel Nekwe, say good afternoon, Manye and lawyer Asma. Nice to hear from you. Tiliduma. I can go on and on and on and on, but let me just pause whilst we continue our program. Now, I'm going to open the telephone lines in case you want to ask any question at all. You are welcome to do so. It doesn't really matter if the topic that we are discussing is the questions that you need to ask. You can ask any question at all. Lawyer Asma, one of our expertise, is here to answer all your legal matters. So the telephone numbers for you to call is 0208 123 1016, or you can also call 073 9920 8468. There is the WhatsApp line. Normally, this line is not usually used on Saturdays, but in this case, you can use it to send your WhatsApp voice note, and we'll play for you on 075 966 20 154 20154, 075 966 20 154. Leaving your voice note, not call, please, just voice note, and I'll play for lawyer Asma to answer your call. So you can bring in your questions now whilst we continue our chat. So lawyer Asma, let me get back to you. There is this person who phoned me with regards to the BRP card he used to apply for, what do you call it? Apply for work. And with these skilled migrant workers, when they come in, already they've put their NI at the back of their BRP cards. We all know that. But then the company insisted that no, they still want a letter from the tax office confirming the NI letter. And we're wondering that the NI is at the back of the card. So why is the company still insisting? Leasma, why is it so? Because when they apply for their skill visas, migrant visa, automatically the card that they gave them, or the BRP card that they gave them, contains, or one of the things on the card actually is the NI number for us. So when you come in, you don't have to apply for NI, but this company insisting. Why is it so, and what must you do if the company is insisting on such a thing from your card? What can you do?
Right, the company is ignorant about the change. And
Mm,
that's why they are insisting. So you have to put them, how to educate them that
mm,
for us, skilled worker, migrant, and dependents, our
mm,
cards already have our NI numbers because the government want to save money, want to save time, and want to give us convenience. Once you explain to them, they will have their understanding and do and just accept it and work with it. If they still insist that it's not the case, you tell them that they should contact the tax office to confirm if the number is coming from them or not. If they still say no, you see, it's a catch-22 situation.
mm-hmm.
You are fresh, you want a job, and especially if you are the dependent, you want a job. And so, because you are the dependent, you don't have a job already. So
Mm,
you want a job, and they are telling you bring this. So you cannot be too insistent on your right that what I'm
yeah.
saying is the case.
Mm,
If they feel if that is the case and you have nothing else to tell them for them to
mm,
understand, you can speak to a lawyer who will get in touch with them by way of a letter explaining everything to them why you should not be providing something different from what you already have on your card. If you are the skilled worker migrant yourself, your employer is the one who brought you. So they wouldn't ask for N9 letter anyway. So it's usually the dependent.
yes. Yeah, actually, it was a dependent applicant who had this very issue with an employer. Thank you very much, Lawyer Asma. So the numbers again to call 0208 123 1016 or 073 9920 8468. You can call in to ask for a question. Actually, I just got a prompt that if you want to ask for a question, it doesn't matter if you don't want to speak the English language, you can go ahead and ask the normal one you are comfortable of asking. So please, let's ask some question. Now we have a question from Mercy Ado. It says, can a man do a divorce without the wife's knowledge? Please, I believe this came out yesterday. We had a similar program about divorce. Eliasma, can a man divorce a wife without the wife's knowledge? Is it possible?
So that would be a sole application for divorce.
Mm,
In this case, the man will have to provide the details of the woman, including address, email, um, address, post address, and telephone number. The court will write to the woman to tell them that this is the application the man has made
mm,
for the woman to acknowledge and to confirm or approve. And
mm,
as we said, the court is minimizing or has removed the need for blaming anybody that it is their fault. That is why the man is seeking a divorce. You don't have to tell whose fault it is. All you have to say is that the marriage is breaking down irretrievably, and between the two of you, it's never going to work. So the court should um, grant that. So can the man do without the woman's consent? Obviously, if they agree to do it, then it will be joint application. But if
mm.
they don't agree, then it will be a sole application. So the man can go ahead, but it cannot be hidden from the woman because the court will inform the woman before the next step is carried out.
Yeah, but how is it possible? You see, with that particular question, if the court has done everything to get hold of the other partner and it's proof futile, what will be the outcome? Would they just say they've done every necessary means and then they can go ahead and then proceed with the divorce, or they still have to wait until there's something positive coming out?
But we also have to draw the line between deliberate attempt to frustrate the process of divorce from the other party. If
Yeah.
the woman is deliberately saying, I'm not going to respond, and I'll
Mm,
show you where power lies,
yes.
then the court is not going to tolerate that. The question that came is quite straightforward. Can the man go ahead without the woman's permission? If the
Yes.
man thinks that the marriage is broken down, he doesn't need the woman's permission. The
Okay.
man can make a sole application. The
Mm,
man cannot blame the woman for his application or
mm,
for the divorce. But the woman will be told by the court that the man has made this application.
mm,
That's first point. The second point is, can the woman choose not to respond? If the
mhm.
woman chooses not to respond, And after some time, the man will tell the court that service has gone and yet there is no response. Therefore, the court should accept that as deemed service. In this case, the court will proceed. So you cannot frustrate the proceedings or the process simply because you are not happy. So it depends on the context.
Yes. So, yes. Thank you very much, Lawyer Asma, for that explanation. 0208 123 1016 07399208468. You can phone in to ask your question. Lawyer, thank you. Now, let me go on to my next question. He says, good afternoon, Manye and Lawyer Asma. I am EU national with pre-settled status. What's the procedure to apply for settled status when due? I believe this person too is a regular listener. So with this question, but well, maybe not just for himself, but maybe the others can also get to know. Loyasma, what will be the procedure?
Thank you very much, our questioner. I want to believe that you have pre-settled status. I think he said. So after 5 years, you apply for settled status and you start the process again. So the same action you took to get to where you are and up to the point of 5 years, you continue the process again to get the indefinite. So if you were sponsored by your mother or father, in other words, parent, and you were the dependent, you have to prove that you still depend on them. Unless you are saying that they are dead or the sponsor is dead, and therefore you have a death certificate to show that you are now relying on retention of right. If it was your spouse or partner, so to speak, then the same process showed you have to show that you still are in that relationship and they are sponsoring you, unless you're able to show that they are dead or the marriage is no longer, there's divorce, then you
Mm.
can rely on your retained right. If you are a child, the same process. Again, if you are so the approach you took to get there, you have to revert, you have to continue the process unless you are relying on your retention of right and you have to prove there has been an intervening factor, death or divorce.
Okay. Thank you very much. I have a voice note here. Let me play that and then let's hear what the caller wants us to hear.
Good morning, Manye. Bibi nti mede me din besie kakra. Na me question a mpɛ sɛ mbisa ne sɛ, me ne me yere na ɛwɔ kurom ha. Na meware no na mewɔ nkwadaa mmiɛnsa wɔ yɛ kurom Ghana. Ɛma meyɛ sɛ mɛfa n'aba. Nti berɛ duruu sɛ mɛfa akwadaa no aba no, ɔka kyerɛɛ me sɛ nkwadaa no bɛba abɛka yɛn ho wɔ kuro yi mu deɛ a, ɛnneɛ ɛyɛ sɛ memfa no saa kwan yi so, ɛyɛ sɛ mepata no, mema no sika. Sika kakra no ɛma kasakasa kakra baa yɛn ntam ɛma ɔfaa ne ho adwene sɛ saa na ɛteɛ deɛ a ɔbɛsɛe me nkrataa no. But ne nyinaa akyi no, yɛaka ama asomdwoe aba a yɛte kama. Na nkwadaa no nso aba abɛduru yɛn nkyɛn a yɛde wɔn application ato mu. Application no mu na seesei afikasɛmfoɔ afrɛ sɛ wɔhia me ne ɔbaa no interview ɛfa nkwadaa no ho. Eti menim deɛ wɔkɔbusaeɛ ɛna I don't know sɛ ɛberɛ a kasakasa baeɛ no so ɔfrɛɛ ɛhɔ anaasɛ wayɛ biribi wɔ hɔ a because nkwadaa no nkrataa no application a yɛyɛeɛ no, Home Office de kan respondoo sɛ ɔbaa no asesa n'address afiri baabi a mete no. Wɔ abrame menim ho hwee nti memfa proof a ɛkyerɛ sɛ akwadaa no ɔne panyin na ɛte. Ɛna mede me m'address ne akwadaa no proof of address ɛkɔe. Nti ɛno akyi na wɔafrɛ sɛ yɛn mmienu yɛmmra for interview. So waka biribi anaa mebisa nso ɔno nso sɛ ɔnkaa biribiara nti mente aseɛ nti sɛ mobɛtumi aboa me kakra.
Yeah, yeah, no, hi, Drew. Lasma, this in fact, when you have issues in your marriage, it really it can affect a lot of things, and we don't hope things we get to this stage where your own kids, you have to continue with the documentation of them to have a status here, and because you had a fight with your husband, it's now affecting the children. Loyasma, and the question that our brother asked, what do you think will be the outcome? What do you think has actually transpired between the woman and the home office? I mean, it can be, legal terms or whatever terms. I mean, just give us a little bit of explanation to this.
I mean, nobody knows what, one, whether the woman has spoken to the authorities, and two, if she has, what the message was to the authorities.
Mm-hmm.
But the man has indicated to us that there was a letter showing that the woman is no longer living with the man.
Yes.
And because the woman is the sponsor,
Yes.
because the children are stepchildren, so the woman is the sponsor.
Mm,
If the sponsor is no longer in the equation, on
mm,
what basis are
yes,
we processing the application?
that's
So
correct.
it might be that authorities want to cross-check certain facts and be clear that the rules are being, the boxes are being ticked in terms of deciding this application.
Mm,
Now, the man needs solution, practicalities.
mm,
There is misunderstanding between them.
yes.
Call it a blackmail, call
Mm,
it whatever it is. There's misunderstanding, and the sponsor is not willing, the stepmother is not willing to assist the children.
that's correct.
However, the children have already met the rules,
Mm,
appendix EU rules and
yes.
EU document application. Family permit has been made and is granted, and they have entered
Mm,
even their application to extend, and because of misunderstanding, this is happening.
yes.
The woman decide not to attend the interview.
Mm-hmm.
The man can inform the authorities whatever is happening.
Mm,
Point out that whatever is happening should not be visited on the children.
yes. Mm-hmm.
Because the fact that there's misunderstanding between us, the
Mm,
two adults
mm,
who are in this relationship or marriage, and
mm,
we understand ourselves, that
mm,
should not be visited on the children. That's the first point. The
mm-hmm.
second point is, what if the woman is not willing to attend the interview? Can the man attend the interview alone?
Mm-hmm.
It's a possibility. However, you have to alert the authorities that this is the case for them
Mm,
to give the permission. So you
mm-hmm.
can see that it's not lost.
Mm,
No hope.
okay.
And what I will ask that this person does is to seek a lawyer in this instance.
Yes.
He should not
Yes.
attempt to do it himself.
Mm-hmm. Mm-hmm.
Because if the marriage is broken down
Mm-hmm.
and there's divorce in place or proceedings that started, that can be a point to raise. If the
Mm,
woman is blackmailing the man, as
mm-hmm.
he has indicated for whatever reason, then
Mm,
that is going to affect the interview outcome.
yes.
So you don't want to jeopardize, because
The,
you can preempt the outcome of the interview if they
mm,
are both to attend. But they have to both attend, because the sponsor must go with the husband.
that's correct.
Yeah. So what I would say is that the man should speak to a lawyer, so that
Mm-hmm.
the lawyer will look at the facts, listen to him, ask questions, and look at what is going on, and profile solution or offer some solutions within
Mm-hmm.
the rules.
Yes, if you are listening to us, I believe you take the lawyer's advice to proceed on this particular issue. Lawyers, you see, with the explanation that you've just given to us, suppose the man in this case has already gotten the settled status. Can he use that or to proceed for the case without the dependent, or since he's getting the status based on the wife, still we need the wife intervention here before they can proceed with the kids? Or would there be that kind of, if I have to wait till I get my indefinite leave or status, can I apply alone without the my wife? Sorry.
Are we asking the question for the children or the man?
Well, I'm talking just in both.
Generally,
In a
generally.
way,
Okay.
yes.
Okay. So for the children's application, there's one sponsor. The relevant EU sponsor is the woman,
Okay.
the stepmother.
Mm,
And the law is that it should be dependent on the stepmother or that particular sponsor
okay.
having arrived in the UK and
Mm.
doing your indefinite, your pre-settled status. Now, if these are children under 21, then the
Mm-hmm.
children will have the status of their stepmother, the
Mother.
sponsor. So if
Mm.
the stepmother has settled, the children will have settled status.
Mm.
Now, we are looking at the time of application. Obviously,
Mm-hmm.
we were together then, or things were okay then.
Mm.
So they were able to indicate that
Mm.
they are both living together, and they might have even provided some evidence.
Mm-hmm.
And now the woman, for whatever reason, has said she doesn't live with a man, so there is separation. And if there is separation, it appears that the marriage is gradually breaking down.
Mm.
But we cannot say that because the marriage is breaking down, the application is based on the man. But we can say that if it's a matter of dependency, the rules say that you depend on your sponsor or the sponsor's partner.
Mm-hmm.
Then automatically the sponsor's partner is the children's father, the biological father.
Mm-hmm.
So if they depend on the sponsor, then they depend on the father. So if the sponsor is not in the equation, they can still say that in terms of dependency, they depend on the sponsor's partner, which is their father. But
Mm.
because this one, the application is already made and some representations have already been made,
Mm.
suggest they depend on both, then
Okay.
you need to speak to both. So that's why I'm saying that he should seek legal advice to
Right.
address this issue. He shouldn't attempt to rely on pocket lawyers to do this. He really needs a lawyer who understands the Appendix EU provisions of the rules to be able to support the children's case. For it's very important that we help the children to secure their leave.
Very important to help the children to secure their leave. If you've just joined us, this is BWF Solicitors Legal Hour. Sorry, Community and the Law. I'm used to legal. The Community and the Law, where we are bringing the law into your doorsteps. Okay, I have a question here, Lawyer Asma. um the question says, my 2 years daughter went out of the house whilst I was out, and my neighbor called police, so I was given a police caution for neglect. It's been 7 years now. How do I take this caution out of my my is it my oh this just stop there. So how
For DBS record.
oh yes, yes. Mhm. He didn't finish, but I think that's what he meant.
Right. I mean, matters of or matters to do with the police, especially children's generally,
Yes,
because if it's a matter of neglect,
yes.
you want to make sure that even though it happened at home to your own children,
Mm-hmm.
you don't want it to be transferred to other children or even you doing it again.
Again, it's true.
Again, it depends on what job the person does.
Mm,
So if the person has tendency to neglect children or vulnerable people, and the person is dealing or working with children and vulnerable people, then the
mm.
profile must show.
Okay.
The question is, how long will this be there? It
Mm,
depends on the screening being carried out.
mm-hmm.
We have the surface screening and deep screening.
Winning, yes.
So
Mm,
the surface screening may not bring out everything,
okay.
but the deep screening will bring out everything. And therefore, the employer or the person seeking the screening
Mm-hmm.
will indicate what the purpose is. If
Okay.
you need the screening for the purpose of work
Mm-hmm.
and work in the care sector
Mm,
or health and care generally,
mm-hmm.
then they will want to make sure that the person is deeply screened, and that
Okay.
might bring something up.
Mm.
So, how many years? What I will say
It's
is, uh,
7 years,
so
and
yeah,
it's
the
caution.
person says it's been 7 years. There are
Mm-hmm.
some, depending on the warning that was placed on the record. Some of the warnings they go off after a period. Other warnings stay. And as
Mm,
I said, some of the warnings, when the
mhm.
screening is carried out, depending on what the screening is for, it will not pop up or will not show on your DBS certificate. Some it will. And
Mm,
again, it depends on what the person will need the screening certificate for. If it
For
is normal surface work, so to speak, normal work, which
mm,
does not involve children and vulnerable people, then
mm,
it might not be relevant per se.
okay.
So can I avoid it? Some of them is very difficult to avoid because police caution, police interviews are placed on our record, and
Mm,
especially if it's going to involve children.
it's true. Oh, so in this case, after 7 years, can he do something by taking it out from the DBS? No, but because it's just a caution, it's not a matter of the.
Exactly. Exactly. It's a caution. And some
Mhm,
of the cautions, as I said, will not come up on your DBS,
mm.
provided it is needed for general regular work.
Work. Okay. All right. Thank you, Lawyer Asma. If you've just joined us, we are still here. We have numbers to call to ask your question. We have one question here. I said, my 12-year-old child wasn't born in the UK but has lived from primary school till secondary school. How do I apply for his citizenship if there's any possibility way, please, Loyasma, is there anything like that? He wasn't born here, but throughout the person's education from primary to secondary is being in the UK. Let's look at the years involved. Is there any possibility?
I mean, that you can see that what I was expecting the person to say that my 12-year-old child has lived in the UK for this number of years.
Yes, exactly.
But let's just assume that they've been from
Mhm.
primary to year
Second,
11 and completed, maybe up to year 11. So
okay.
year 7, year 8, year 9, year 10, year 11, that's 5 years.
Mm-hmm.
Then year 1 up to year 1, year 2, year 3, year 4. Now, so the point we are making is the time you finish primary 6,
Mm-hmm.
the child would have already covered 6 years, even with nursery. Let's assume that they didn't have nursery education here. So
Mm-hmm.
6 plus 5, that's 11. So if the child was born abroad, came to the UK at the age of 1 or 2, then they will be 10 years, at least 7 years in the UK. If the child has lived in the UK for 7 years continuously, the child can apply for indefinite leave to remain. So the years we are looking for is 7 years. If that is the case, and the child has lived here for 7 years, child can make application for indefinite leave to remain. And otherwise, they have to wait. But if they have indefinite leave to remain, and that is to start with, that's better. So if the child is then put in the application as soon as possible for indefinite.
Leave to remain. Thank you, Lasma. I've got some couple of audios here. I don't know why the person didn't send it through the WhatsApp so I could play it through the system. But let's see if we can hear it properly from the phone. Loyasma, sorry.
Yeah, good morning, Maninati. Good morning, lawyer. All right. And then I'm just saying, you mama bomma on my. But the thing is, a brand be on or a dependent for a student, which means only student we and only dependent visa the buy. Number two, you know what jai. So much, Okushia or baby or British knee. How about no Ghanaian descent? Guy is a Ghanaian knee. Nti omo akoye customary marriage Ghana omo de aba omo de ba be application for 2.5 years. And the same was I said, minim say we are British near na be so shebe na wala oni ko krum. No akoye aba. But we know say na we dependent na oba na answer na oja no. Na o leave no enwe ni leave ni nti musa say ebe ye. Omo akoye customary marriage no Ghana a omo anko na obi aye de abro omo busa na de abro omo. Omo ye application be fa. That's hello man.
Okay, Loyasma. Yeah, sometimes these things are, over the board. What advice can we give to this person?
So the first point of advice is that the man should divorce the previous partner whom he depended on to enter the UK. But
Mm,
without the divorce, the new marriage will not be valid.
mm,
That's point one.
okay.
Point two, they have met physically in the UK. So they've met in person in the UK. I'm talking about the new lady. He's
Mm,
met the new lady in the UK.
Mhm.
and they have decided to use the provisions of the Ghanaian law on customary marriages to marry by proxy. So the
Mm.
families have represented them to do that, and they have registered their marriage under the
Mm.
provisions of the 1885 and other provisions of the customary laws of Ghana.
Mhm.
That is it. The marriage will be valid.
Okay.
This question is, will the visa be granted?
Granted, that's the
The
thing.
visa granting is not the conversation on any platform at all, because that is the job of the case worker. Your
Okay.
job is to make sure that you have met all the requirements and provided all the evidence.
Mhm.
So what a person is doing is to literally switch from dependent of a student
Mhm.
to Appendix FM, a partner of a British citizen
Okay.
application. And this is going to be Appendix FLRM
Mm.
application, because it's marriage. So once you go through the process, once you follow the rules, and once you tick all the boxes and provide the necessary evidence, then the caseworker will find it difficult to say no.
Okay.
And if they say no for whatever reason and it's a mistake, you can seek a review or you can go for appeal.
Right. So in this case, the new wife, well, I didn't get that bit quite well. The new wife has got status here. Then the new person has
The
gotten
new
status.
wife is British citizen. That's
He-
what he said.
Okay, then that's fine, because I was thinking the moment you divorce your dependent um husband or wife, then you are left with nothing, isn't it? You don't have any status after that first divorce, because you are depending on someone, and now you've divorced that person, so you are left with nothing. Is
Yeah,
that?
yes. So yeah, that's a point to make.
Mhm.
Obviously, you have to divorce, and
Mhm.
after divorce, you have to check what you have. But
Mhm.
this person is living in the UK, making the application, and that is where, if there's no child involved,
Mhm.
it makes it a bit, I wouldn't say contentious, but the key thing is it gives too much power to the caseworker to say that if you genuinely want to marry and you
Mhm.
love the lady so much, then
Mhm.
it doesn't matter where you live your life in the world. You can
Mm.
go back to your country and live your marriage life. But
Okay.
but if there are insurmountable obstacle or child best interest of children in there, then you
Mm.
can rely on that. That maybe my wife is very ill and needs me to be able to support her with daily tasks and livelihood. That is one point. If there are children involved, then the children's best interest is paramount. So we can consider that. So all these things will come together. That is why the question of a year is not the point, but it's the point of meeting the checklist and making sure that you have satisfied the rules.
Thank you
And
very much.
your point is valid that at the point where the person has divorced the
Mhm.
main sponsor in terms of the person, the main student, would the visa be valid? Well, if you don't have a dependent, then your dependent visa is no longer
Mm.
useful.
Yes.
So
I've got a
this
second
is-
audio. But before I play that, talking of dependents and main applicants and stuff like that. There's this question. In fact, I get like 20 people asking me a day. If I'm a dependent and I switch to get a sponsor, is it automatic that my husband or my wife, who I dependent before, will also get the status I have, or they also have to apply based on what I've gotten now? Is it automatic, or they have to apply? Like husband.
I mean, you see, this is what it is.
Mm.
The main person is already working, so we don't
Yeah.
have any argument there.
Mm.
They can choose to be there, or they can choose to migrate onto their husband or their wife's
Oh,
status. If
okay.
they choose, if they want to become
Mm.
dependent instead of men.
Okay.
But once the dependent decide to also get a job and
Mm-hmm.
become
And many.
independent,
Yes.
then we have two independent people.
Okay. Okay. And
Yeah,
what is keeping them together is the marriage, isn't it?
they are still married, but everybody is independent because sponsored by by different employers. So so what it means is that the dependent cannot choose which work to do. They have to work for the employer they have found for themselves.
Okay. So in this case, where the main applicant, the previous main applicant's visa is getting to expire or nearly expired, and the dependent gotten her or his sponsorship. Okay. After your dependent getting the sponsorship, they didn't actually maybe inform the main applicant, or the husband or the wife. They are all together living, and everybody is living individual lives. And then the first applicant visa expires. What will be the outcome? Must he also apply based on the new sponsor, or once they are still married, they are okay? It automatically covers him or her.
There's
If you
nothing there's nothing automatic. You always have to take active step
Mhm,
to apply to be linked to your dependent
mhm,
your partner's status, or you
yeah,
go your separate way. Now, if the person's visa 3 years is expiring or getting to an end, they have
mhm,
to renew, don't they?
yes,
If the employer says they are not renewing because their job
mhm,
performance has not been satisfactory,
yes,
before it expires, that person can now come and become a dependent upon the the dependent or the husband or wife who has become independent.
mm,
Because there are two options. So the first one is that the lady is working with the original employer.
okay,
The husband was under her, literally.
yes, mm-hmm,
Then the husband decided to become like her,
mm-hmm,
also going his own way.
yes,
So
mm-hmm,
this lady is going, so they are now moving in parallel order, different employers.
okay,
If the lady's time is up,
mm-hmm,
she has a choice to continue with the employer by renewing it,
oh,
or switch to become a dependent of the husband who has also become independent.
right,
It's
mm,
a choice.
okay, okay, yeah, I get it. Now let's hear the second audio.
Good morning, oh. Uncle Ben, good morning. I'm Monseneg Mapam, Bomokom, Namisha, Happy New Year to you all. Quick question about coming with Sama, my friend, back on Bacho. Why apply for settlement visa? I'm an about organ and about 9 years. Na visa no aba pesa akwana but osi onya ho enkongo fa akwana because o matu a ontimi nya obi afa na single mother na pese nkoma host be for edoba na ma cheno no procedure na etise so ba organ na pese o de ma flight ba etise one and two ne ba no yaman settlement indefinite oba no ma me no so indefinite no o pese go ba ankobet me apply principal for ma akwana after 1 year ma me no se ontimi nye life in the UK in English testing or no. And I don't bit my TV. But that's it. The banner of the 1 year on the indefinite with my British passport. That's the question that's in it. So, good morning.
Okay, yes,
I mean, what, yeah. What we're going to tell our friend is this, that the child coming,
mm-hmm,
first off, should be by way of the parent accompanying the child.
yes, mm-hmm. Oh, I think we had a break over there. I'm sorry, listeners and viewers. We are back. Lawyer Asma was on. I think we had a glitch in the transmission. Let's just quickly have a commercial break whilst we fix this. I'll be right back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back to the community and the law. Thank you very much. If you are still here with us, we are glad, and we are still here continuing the questions that we had. I'm very sure now the transmission is fixed and Loyasma can continue with answering the question. Other than that, very soon we'll bring in our quiz, our popular quiz, and we all remember the nuggets that Lawyer Asma digested it for us, and I know in some few minutes, I'll bring the questions and I'll ask viewers and listeners at least to try their knowledge on, and then after that, we'll bring Lawyer Asma to explain once again for us before we come out with the answer. So, Lawyer, before the break in transmission, I asked a particular question that you were just answering. If you can continue that for us.
Yes. So regarding the child, because the child cannot be accompanied at this stage,
Mm,
they have to check the airline and speak to them whether the child can be um, brought to the UK unaccompanied. There is a procedure for that regarding a particular airline. Some airlines do not allow that. Some do allow for the child to be sent here unaccompanied, either by the airline themselves or through a friend or somebody coming to the UK that the parents have authorized them to bring the child. So they have to check with the airline if they will accept, and if somebody that they trust and know has their permission to bring the child, then that's possible. Otherwise, they have to go and literally bring the child to the UK.
right. Thank you. There is one also here. Let's listen to actually two, as a matter of fact. Let's listen. I think just after 5 minutes, I'll bring the quiz. Let's hear this one.
Pacho bibi wale African na oya British by Ghanaian descent. Na mabedria no I ware metro 5 years to manya me British passport. Na ya wale no ayabasa I from January be ya ayabasa ntimi ko Ghana year we be February March na mkushi o baby. Akonwa busiafo no bibia e boko nti. Say me ne me no wa na the divorce no atom o UK ase. But ate inyanya humpu bi am latest bibia ba sensan de ko. But now obi ka bibi say enka metimi ayede we ni kwa dem na ni metimi akọ Ghana akọ Ghana de no court divorce judicial divorce no anase me metimi ma family no akọ judicial divorce na ma me na ma be yiso no nanka metimi akọ wale oba no ko we 8 le biso me do oba am person ko wale no ti question is say me jai had de na pen na sem ko ye Ghana divorce de ba na me the application for new na ko marriage no me ma ko for new marriage na metimi ayusu sa divorce amen Ghana and aware ada application because anything because I'm saying old marriage no and timpacho mami muwa and yet the medical ko ban de me san ko Ghana nanka mama ma judicial divorce na bananka de na ya ware no that's it. Good morning Manyanati. Good morning lawyer.
Oh dear. Sorry. My is frozen. The phone is frozen, so I can't switch it on. Oh dear. Sorry about that. Lasma, can we answer this gentleman?
Okay. I think our brother needs help. So
Yes.
we'll attempt to help the best way we can,
Mm.
and I will speak to him as a brother as well.
Yes.
He's met the new love is good.
Mm-hmm.
He's already put in the application and the proceedings ongoing.
Mm.
What I will ask him he does is to follow up on the process so that he can get, because if the application, I don't know whether it was done under the old regime or the new regime,
Yeah.
but either way, under the new regime, 20 weeks after the application, you should be getting your conditional order, especially if the other person has responded. Then
Mm.
after that, 6 weeks, you get your final order. So, and the old regime, of course, things could delay, especially if the other party has not responded. But if everything is ticked off, then I don't see why the delay. He can follow up the court so that he can get the certificate because he's already started the process in the UK.
Mm.
The question is, if he goes to the other country and gets it from there, and
Mm-hmm.
this one also goes through, he has two divorce certificates.
Mm-hmm. Yeah.
Which one will he be using at which point? So what I would say is that once he started this process, he should follow it through and rather follow up consistently so that he can get it sorted for the next project. The next thing is that if he also feels that he wants to at least see the new love and spend time with the new love, he's got British passport, so nothing stops him from spending time with the new love wherever she is, whilst the divorce process is still ongoing.
Mm.
Yeah. So, but can he go for another proceedings elsewhere? He chose the one here. So I think the advice would be that he should complete the one here.
Mm. Yes, Lasma, that's it. Let's bring the questions for our quiz, and then I believe those of you still online with us. Alex said, Alexa said, long time no see now. Yeah, good afternoon to you too. So, Tilly Duma, I know you are here. Bob Asari, you are here. Ezekiel Johnson, you are here. And Nana Etiahene, you are here. Let's hear the answers that um, based on the nugget that we brought. So this is the question. Uh, it says at an appeal hearing before the Immigration Appeal Chamber, is it JAC or IAC? Well, I believe it's IAC. The representative from ABZ solicitors complained that the judge was asking questions to develop his own theory of the case as distinct from adjudicating, between the submission of the parties. In effect, the solicitor felt that the judicial intervention was inappropriate and was done in a hostile manner. The appeal was dismissed by the judge, and ABZ solicitors appealed to the upper chamber, citing unfair and hostile judicial intervention. Hmm. Straightforward. What will be the likely outcome of the further appeal? So earlier on, I think Lawyer Asma gave us a little bit insight about the nugget and the questions for this particular outcome. Let's hear you. Number one, it will be allowed because the manner of intervention is also important. It should not be done in a hostile manner or in a manner that suggests the judge's mind has been made up. Number two, it will fail because the judge is allowed to ask any questions to move the case forward. Number three, the judge is the only person who can progress this case so the appeal will fail. Which one is the correct answer, ladies and gentlemen? Someone will say, I miss my brother. Oreku say Pampana. Let's look at the answers. Is it A? Is it one? Is it two? Is it three? An appeal hearing. The outcome that came and the uh, intervention of the judge. Let's hear the answer. So, Emmanuel Sechi, thank you so much. You said number one. Let's hear from you. What will be the likeliness of the further appeal? Margaret Edujemfi, where are you? Tileduma, where are you? Let's hear Alex. Alex, where are you? What will be the answer? What will be the answer? Pampana, Pampana. I miss my brother. Reku, wherever you are, very special greetings to you. Emmanuel Nike, let's hear you and let's come up with the answer. So Adai Mununkum, hey, big boss, long time. Adai says yes. And number three, Adai says number three. Please, let's hear from you. We have a limited time. Let's see before Lawyer Asma will come in again and then give us just a gist of it for the right answer. Who else? Who else? So Lawyer Asma, this intervention thing, I think I've already asked some few questions about this, and then I believe whoever actually goes to court regular will notice some of these behaviors when it comes to judicial review or judge interventions and stuff like that. I remember there was one case that I attended three judges, and they didn't actually allow the one of the lawyer, I think the defendant lawyer, they didn't allow him to say anything at all these three judges were just saying stuff. And I thought normally there is, I've forgotten the name, but there's this person that actually reads out the what do you call it? Oh, lawyer Asma, you always go to court. you know
Well, it depends on the court we are dealing with. I mean, if it's a case of magistrate court or the crown court, if it's a criminal
Mhm.
proceedings, then we have the prosecutor who is
Yes,
making his or her case,
the
and
prosecutor.
the defendant will come in through his or her defense team. But if it's immigration
Mhm,
chamber or appeals,
mhm.
then we don't have somebody to come and recite a case before the two
Oh,
appeal and
yes.
the
Okay.
case starts. So it depends on which area. Again, if it's a civil case,
Great.
we don't know. We don't have to. So it depends on which particular court we are dealing with or matter we are dealing with.
Think I have to attend all of them because it's good. Sometimes you see, when you just sit down and then you look at what is going on, it really enlightens you how judges behave sometimes, what to proceed with stuff, and then how lawyers will correspond or respond to defending you and stuff like that. It's just something and that we all need to embrace ourselves with. So the answers again, one, it will be allowed because the manner of intervention is also important. It should not be done in a hostile manner or in a manner that suggests the judge's mind has been made up. Number two, it will fail because the judge is allowed to ask any questions to move the case forward. And number three, the judge is the only person who can progress the case so the appeal will fail. What will be the right answer? What will be the right answer? So we have just about 2 or 3 minutes. Let's wait for a few more answers and then we can proceed with the rest of it. Hello, Asma. Before that, I've got Daniel Poku. Thank you. Daniel Poku says answer number two. I've got one question. If somebody gotten a refusal based on representing documents and two separate documents on the same thing. What I mean, two separate documents, like two birth certificates, but the same person. And this birth certificate, the dates on it are slight difference from each other, and this person happens to apply for a skilled migrant route. Based on this representation, what chances has this person got to be secured a skilled visa to come and work? If you can give us a little bit on that. Tilly Duma, Tilly, thank you. Tilly says number 3. And Kwame Prepare says number 1. Kwame, thank you. Lawyer Asma. Mm-hmm.
Yes, so now, I mean, I think you don't even have to be a caseworker to be confused with two birth certificates of the same person, two dates of birth.
Mm,
Why didn't they make a decision to decide which birth certificate is for them
mm.
before they confuse the caseworker?
Okay.
The caseworker
Mm,
is confused. They will say, no, there's something fishy going on.
yes.
And the application will be refused under paragraph 9 of
Oh,
the rules.
okay. All right. Thank you very much. Due to time factor, let's hear the answer. So Tilly says number 3. Emmanuel Sechi says number 1, and Daniel Doku number 3. Emmanuel. So yes, Loyasma, what would be the answer, and why is that answer the correct one? If you can elaborate that for us, please.
So what we have learned through today's nugget
Mm-hmm.
is that under the rulings of the case of Bangladesh 2023 and the case of Porter versus McGill 2001, a
Mm-hmm.
judge must be a referee, independent referee, free and fair and just to both parties. The judge must not be seen to be doing things that would suggest that he or she is being partial.
Mm,
And if that comes across, the other party that is not happy with that behavior can complain against the judge's behavior.
mm,
And the person will cite the case of judicial intervention, which is not undue judicial intervention. And once the decision comes through, automatically the person will appeal against it. And if it is found that that happened, the case that the dismissal will be set aside so that the matter is heard again. So if it's a case of the person complaining and appealing against that decision, then
mm-hmm.
of course that appeal will be allowed because the manner of the intervention
Mm-hmm.
was maybe biased,
Mm-hmm.
inappropriate, hostile, and unfair.
Mm. Bias, inappropriate, hostile, and unfair. So our answer is number 1. So Imara Sechi, you are right. And who else had it right? I think about 2 other people. Kwame Pepra, yes, Kwame Pepra also had it, and then somebody else. I'm sure we had 3 people with the answers. So thank you very much. This is what we do. Each week we bring in this nugget for you. It's on our platforms and BWF Solicitors, Facebook and YouTube, our Twitter, our Instagram. We bring this nugget just to enlighten you. We have what we call it, motivations of the week, and even daily ones. We keep on reading them. It's something just to keep you going, So as we get in close to the program, I'll once again invite Lawyer Asma to give us the last. But before then, there's one question that just popped out, but our time is almost due. Yes, Emmanuel Sechi, yes, you got it, you got it, you got it. You are right. I know. Due to this community and the law and the Thursdays ones that we have on Rainbow Radio and the ones that we have on Magneti, that's Fridays one legal hour, a lot I can say a lot of people are now becoming pocket lawyers in some way. The other time someone was just challenging me, and I was like, oh, how did you get to know this information? He said, oh, but you forgotten you've been educating us on every week 3 times a week. So I know we are getting it, and very soon, very soon. Just that don't go and get someone's money and then represent that person. You are not a professional lawyer, but we are getting there. We are getting there. Before lawyer Asma comes, in case you want to write your B1 exams for either citizenship, or you want it for IELTS for B1 IELTS, sorry, for carers and or skill migrant routes, or if you're a nurse and you want to write your OET, you are all welcome to KT Consult. In fact, we've gotten new learning materials, even fresh, even those that just last week came out. We've been able to get hold of some of these materials and we are using them. So when you join KT, there is no way you will go twice. It's just one shot, and we are proud to announce that we have a whole lot of testimonies. And yesterday, one results that came, I was really shocked because that person, I was like, okay, you just go and try, because he really wanted to, and that person had over a 8.5 in all. I was like, oh my God. So Katie, at least we are doing something. So come register with us if you want your English at the level that is required. Just come and register with us and we can take you through. We have classes each week, twice, learning and teaching and learning, and we have exams preparation. So join us and we will not disappoint you. Community and the law will come on same time next week. But before, Layasma, what can we take throughout this week before we meet again?
So throughout this week, what we are saying is that if you have indefinite leave to remain in your passport, you can transfer it to a card, and it's so easy. All you need is to apply, no fee to the Home Office, show evidence that you've lived in the UK since you got your indefinite leave to remain, and your card will be processed, or application will be processed, and your card issued for you. We should also bear in mind that when making children's application for a skilled worker dependent, it's become a very challenging thing for children whose parents or parent is or are living in the UK. If both parents are here on the program, it's easier. But if one parent is here and the other parent is a step parent, it's difficult for the child, because the parent who is the main parent must show sole responsibility and must also prove that the child will not be able to cope or survive in wherever they are, if and therefore must be brought to the UK. That's the bit that is coming up every time children applications being refused. So please, when you are applying for your child as a dependent migrant in the UK, make sure that you tick all the boxes. If you are not quite sure, let a professional do it for you so that you don't go and hit the brick wall and return, and to cost you too much money, and there's
Yeah.
so much anxiety in that. So that is a bit we will advise. Again, if you're a student and you are currently studying or intend to study and you intend to bring your family, please make sure you do that before
December.
January 2024. We don't know what's going to happen, but we just want to believe that once we are able to do everything now, whatever happens next year, we will not be worried because we would have taken the steps to do what we need to do. Thank you very much for making time, and it's been a pleasure. Enjoy the rest of the weekend, and shalom.
Shalom. Enjoy the rest of the weekend. On that note, I'm also going to say a very big thank you to you all staying throughout from the beginning till now, especially till Liduma. So shout out to you, and then all those celebrating their birthdays today as well. A very great happy birthday to you. And until then, my name is Tomanyeti. I'll see you next week. Have a lovely day. Bye bye.